And we're live. And we're actually live a moment early because I hit the button accidentally before 8 o'clock. So I am just going to uh, vamp a little bit um, uh, until it is actually 8 o'clock. Oh, it is 8 o'clock. And we're live. It is Friday, October 17th, the year of our Lord 2025. It is 8 o'clock a.m. And I have some important announcements this morning. The first is that this show is going to be loud. And there are two reasons for that. The first is that I have two agitated dogs with me in the room. And the reason they are agitated is that downstairs is a chimney sweep who is doing the annual servicing on my wood stove in my living room. And the dogs do not like that they are separated from the chimney sweep because they desperately want to run downstairs and greet him barkingly. And for reasons you can imagine, the chimney sweep is not eager to be greeted by two very enthusiastic dogs. And so he is downstairs with some very loud equipment, which you will probably be hearing over the next 20 minutes or so. And the dogs are upstairs complaining about the cruelty of the separation. And the result is you're going to get some background noise here, and much of it will be Cleo whining and occasionally barking. There will probably be some loudness associated with actually sweeping out my chimney and the removal of creosote from uh, my chimney. But I'm sorry, we do authenticity here on the show, and authenticity means that when it is loud, and sometimes that's background noise. Sometimes it is excited dogs and chimney sweep. And the second reason this show is going to be loud is my guest, Janine Balekdjian. And I want to tell you a story about just how loud Janine Balekdjian is. I was at her wedding about a year ago, and Janine Balekdjian's wedding was officiated at by not one but two federal judges, one of whom she clerked for, and the estimable Judge Lynch made a joke in the ceremony
It was
about
Judge Kelly.
What?
Judge Kelly.
I'm sorry. Judge Kelly. Bad Ben. Judge Kelly, whom I have praised on this show before
He's a
for
great
his
guy.
handling. He is a good guy for his handling of the Proud Boys trial. And also for his, I expressed confidence when Judge Suknanan's case on recently was transferred to him on one of these awful immigration cases, and the story was case moved from Suknanan to Trump judge. And I said, no, I have total confidence in Judge Kelly. And he's a serious guy. He's a very good judge, and I have confidence that he will handle this case very appropriately. And he did, and he issued an excellent opinion on the subject. Anyway, all of that is merely by way of saying that though I just misnamed him, I do know who I'm talking about. I, in fact, sat next to him at dinner at the OLC and judge table at Janine's wedding, and we had a lovely chat. But during the ceremony, the point is, he made a joke about Janine being loud, and I believe the joke was something along the lines of, "I hear you, Janine, and so does the rest of the E. Barrett Prettyman
Yep,
courthouse."
that is memorialized in my wedding ceremony.
Yeah. And so I just want to say, between two agitated dogs, one chimney sweep, and Janine Balekdjian, it's going to be a loud show. Um, and the dogs seem to have settled down, which I assume can only mean that the chimney sweep has left the house to get his very loud equipment. It's going to get loud again. We may be joined by others, but you all asked for a discussion of the institutional role of the Office of Legal Counsel. And I can tell you that there are people of my acquaintance and people who've come on this show who have higher level experiences than Janine at OLC. There are even people who've had longer experiences than Janine at OLC. Um, there is nobody who is more fun and more eccentrically willing to come on this show than Janine. And I just want to say, Janine came on this show repeatedly as a sitting OLC attorney to talk about other things. And that is something that normal OLC lawyers do not do, because they are kind of a buttoned up type. They are, you know, the word tight ass comes to mind. Um, uh, these are the people who did really, really well in law school, and
What, like I didn't?
no, you did, but I'm just saying you're different from no, Janine also did really well in law school, but like let it all hang out about anxiety dreams and wears sparkly stuff and talks about Taylor Swift and does not shy away. And by the way, at the Justice Department, she was like the official cosplay person who, when it was Halloween, it was her job to get dressed up because she was the only one who was like chill enough to actually do it. And didn't take herself so seriously that she wouldn't dress up as a vampire. And so all the other OLC lawyers would bring their kids to trick or treat from Janine. And Janine would stand there with like dressed like Dracula in the Justice Department. So the point is, and she would, while she was an OLC lawyer, she came on the predecessor show to this to talk about anxiety dreams. And I want to say that in the history of OLC, I think nobody, current or former, has ever done anything quite like that. So when I thought the other day, and we had a series of questions from the audience, whom would it be just fun to hear from about the role of the OLC and the OLC attorney? I thought, you know, let's have Janine, to heck with, Don Johnson, or, Ted Olson, may he rest in peace, or Antonin Scalia, may he rest in peace. Um, you know, Marty Lederman may show up, Jack Goldsmith may show up, but the person I want for this show to explain this all to you is Janine Balekdjian, nicknamed the Balek, which is a nickname that I gave her. Look, the sun is shining, the birds are chirping, the dogs are wrestling. It's going to be a great freaking day. And you are watching Dog Shirt TV. And it's a goddamn revolution in morning television. And one of the revolutionary features, of which there are many, is that when the dogs get agitated, we don't do anything about it. We don't shut them up. We don't move them into a different room. We just run with it. And another one of the revolutionary features, of which, as I emphasize, there are a whole bunch, is that we don't always, take the most senior official we have access to. We don't always take the person who's written the famed law review about OLC. Like, we could have asked Trevor Morrison to be here. Um, uh, we ask the most fun person who is capable of addressing the subject, all of which is a 10-minute long-winded way of saying that we are not allowed to have fun anymore. Boats are blowing up in the Caribbean Sea as we speak, but we are allowed to have an institutional conversation about the Office of Legal Counsel with Janine Balekdjian, who, by the way, I met because she stalked me on Twitter
This is
back in the good old days of Twitter. So, Janine, let us start. That is an introduction worthy of the ages. But I want to say
that very kind and only slightly dubious introduction.
I will stand by that introduction. And so I want to start by you are now a former OLC attorney, and we're going to add that to your Chiron here. It adds a nice symmetry to my Chiron.
Right, yes, that makes sense.
And so, first of all, when did you work there? When did you step down? And what are you allowed to tell us about what you're going to be doing next, if anything?
Sure. So I joined OLC almost exactly 5 years ago, in October 2020 at the tail end of the first Trump administration. I was there through the entire Biden administration, and I stepped down this past July. I have been in fun employment land since then, which is great. And I am starting a new job on Monday. I'd prefer not to say what it is, just so I don't drag them into any nonsense opinions I might have on this show.
All right. We are not going to discuss what Janine's job will be as of Monday. I will say I have a lot of resentment at this new job because it is not in Washington,
That's
D.C.
true, yes.
And that means that Janine and my occasional get-togethers for scotch and other libations are now curtailed. All right, so let's start with the basics. What is the Office of Legal Counsel? People, all of a sudden, it started, I think, nobody ever talked about the Office of Legal Counsel except in law schools, and until John Yoo was the deputy head of it and wrote some torture opinions and some stellar wind opinions. And people developed a lot of misconceptions about it in that context. But let's just start with, politics aside, controversies aside, what is it?
Sure. So the Office of Legal Counsel is kind of like it is the part of the Justice Department that provides legal advice to the executive branch. And this is to the White House and also to agencies that might ask a legal question. OLC has a bunch of buckets of things that it does. It essentially reviews lots of stuff for legality. And the type of stuff that it would review are executive orders, which until this administration, it used to approve for form and legality. It is now conducting legal review of them, but not necessarily approving them for form and legality. And anything the Attorney General signs. So both Attorney General memos and Justice Department regulations would typically go through OLC form and legality review. And then what OLC is most known for, although it's actually a fairly small percentage of OLC's work, are these formal opinions. And these opinions, OLC writes opinions when they get a legal question from the White House or from the head or the general counsel of an executive agency, or when two agencies disagree sometimes. And when OLC issues a formal opinion like that, it is a binding legal position on the executive branch. But in addition to formal opinions, OLC provides a ton of informal legal advice. And that is what was like my bread and butter typically when I was there was we just get, agencies would send us emails saying, can we do this? Or like, we're trying to put out this regulation and we're not sure whether this statute allows this. So it's kind of an all-purpose clearinghouse for good legal advice. And in addition to reviewing the executive orders and attorney general orders and issuing legal advice and opinions, it also, OLC had a bill comment practice where it reviews certain pieces of pending legislation for constitutionality and sends comments to Congress saying like, hey, you stuck a legislative veto in here that's been unconstitutional for 30 years. What are you doing?
Think of those as like signing statements or statements of administration policy on constitutional issues, right?
We have a bunch of comments that we send to Congress that don't necessarily rise to the level of a signing statement, but when there is a signing statement about a bill, we would certainly review and contribute to it.
All right, so
sorry, I can't stop saying we in the context of OLC.
We will understand we as you in your former life, sort of the way I say we to refer to Oberlin students or Washington Post editorial page writers.
There's a comment in the chat I just want to address very quickly. So Andrew says it sounds like administrative regulations are opinions from agencies, but I take it not subject to APA. Actually, so the OLC's practice of reviewing regulations kind of exploded under the Biden administration. We review all attorney general regulations, but not necessarily other regulations, but OLC was called in to review other regulations. And like most of what we're doing when we review regs actually is reviewing for compliance with APA principles and with the organic statutes. So we do a lot of administrative law work.
All right. So this sounds like an immense amount of work. And for those of you who don't, say, run a legal publication that writes about the federal government a lot, the volume of material that Janine is potentially talking about is immense. And yet the office is quite small. How many people work for OLC when it is actually staffed?
When it's fully staffed, I feel like we're in about the 25 range. Like 18 to 20 career people, of which I was one. I was an attorney advisor. There are also a few senior executive service. And then 5 or so political appointees at the deputy attorney general, principal deputy level. And then, of course, the assistant attorney general is the head of OLC.
So it's a small office and it has an immense potential workload. What are the factors that actually limit the workload? All the agencies that need all the informal legal advice, every formal document that the president may issue that might require form and legality review, every freaking legislative veto or appointment clause problem that may show up in any piece of legislation. What's the mechanism? Plus, you have to sign off on whether it's okay to blow up boats in the Caribbean Sea. What's the mechanism by which this titrates down to a manageable workload for 20 to 30 people?
That's a great question, and I feel like you should ask my former boss that. I'm not sure that I'm totally sure about that. One thing is that OLC certainly doesn't review every legal action that an agency is taking. Typically, like an agency would have to come to OLC and say, like, hey, we want legal advice on that. And that typically happens when the question is very difficult or controversial or there's some sort of disagreement. But agencies have their own general counsel and they take legal actions all day, every day, and that has nothing to do, that does not go through OLC review.
Right. This was exactly the answer
Okay.
I was looking for. That OLC think of it as a place that the agency general counsels will go when the question is hard enough or consequential enough that they don't want to decide a matter on their own. And that for routine stuff, you don't go to OLC. That's what an agency general counsel is for. Is that fair?
Yep, that's totally right.
All right. So, um, John Hawkinson asked a very important question, which I put up on the, um, uh, you know, which is, does OLC sua sponte read the newspaper? Hey, we hear that the administration is doing X. Here's a legal opinion about whether it's legal or not. I take it the answer to that question is no.
No. Well, OLC attorneys do read the newspaper. But
As somebody who has twice gone to OLC and given talks, once in my capacity as a representative of the Washington Post and once in my capacity as the editor of Lawfare, I can tell you that yes, they read the newspaper. Some of the most difficult questions I have ever gotten from audiences
yay!
are from OLC sitting around that conference table.
But no, OLC does not sua sponte reach out and grab legal questions. Someone has to come to us. Like I said, typically we would interface with an agency general counsel or the White House counsel's office.
So hypothetically, let's say an agency wants to do something flagrantly illegal. Say, indict somebody they know to be innocent, or um, or do something in the foreign policy realm that they know if they ask OLC, is this okay? The answer is going to be no. What compels them actually to seek OLC's advice at all?
That's a really good question. And it's actually, I asked a similar one to someone from the White House counsel's office when they came to give the kind of lunch talk that you gave. When do you guys are all lawyers, when do you answer something in house versus when do you reach out to us? And I think it's kind of I'm not real. So I was just a line attorney. I just got the questions or some questions and tried to answer them. I was not at the level where I was the one, receiving inquiries from agencies and interfacing with them. But I think that and someone would ask OLC a question if even if it's something they think is dubious. Sometimes if they want kind of a well-reasoned legal opinion saying like, yes, this is dubious, or like, no, we don't think this is the best reading of the law. Sometimes it can sort of just put ideas an agency is not comfortable with to bed. And other times when when they really want our imprimatur on something, even if it's dubious, well, I'm not quite sure.
Can I poke you with a particular idea of the answer to this
Okay.
question? Nothing. There's nothing that forces an
Oh,
agency
yeah.
to seek legal advice. And one of the institutional problems that OLC presents is that, you know, if you want to act illegally, just don't ask them. Right, is actually now you get yourself in all kinds of trouble by doing
Right.
that. But like when, say, Letitia James files a motion to dismiss with, you know, for reasons of vindictive and malicious prosecution, and it prevails. But you know, but there's nothing forces you to ask legal advice, just as nothing forces a company contemplating a given course of action to go to outside counsel.
That's exactly right. Yes, I think I misunderstood your question and I apologize. But yes, agencies don't have to come to us. Nobody has to come to OLC.
And so, all right, so let's talk about the function that I think drives the sudden interest in OLC as an institution among the Greek chorus, which is this history of the office issuing fairly controversial, sometimes extremely controversial, we might call them executive power forward opinions across administrations, but particularly in situations involving aggressive actions in the national security context. In your understanding of the matter, to what extent is OLC's role to provide an honest, dispassionate legal advice? Yes, you can do this. No, you can't do this. Here's what the law is. To what extent is it an internal court within the executive branch? And to what extent is it there to write CYA memos in these situations to justify whatever the president has decided to do anyway?
I strongly believe that OLC's role is to provide the best legal answer to questions that are put before it.
And is that an aspirational statement or a dispassionate statement?
It's a little bit of
or a
both.
descriptive statement?
It's a little bit of both. It's mostly descriptive. There are times when, and this happens across administrations, when OLC, I feel like, is heavily leaned on, saying, you know, this regulation is a real priority, or sometimes they'll come back and say, like, well, we're not asking for the best legal answer. We're just asking if this is like legally, if there's a plausible argument, to which I get grumpy and say, like, just go ask the civil division. That's not our job. But I do feel...
And just for those who don't know, the civil division is the component that would have to make that plausible argument in the event that the action in question were challenged.
Right.
And so what Janine is saying there is, don't ask me. I'm supposed to give you the best answer I can. Go ask the litigators who would have to defend this stupid idea if you actually did it.
That's right. And there's a difference in standards of, and this is not, I don't mean standards in like a term of like how high you hold yourself, but OLC and the civil division have different roles and are doing different things. OLC's role is to provide the best legal view of an answer. And I do want to say, we're not a court. OLC is located within the executive branch, and I think has a sort of set of priors that are fairly pro-executive, priors that I believe in, by the way. This has nothing to do with this particular administration. And also it has its own, OLC considers itself basically bound by its prior opinions unless it decides to overrule them in a little bit of the way that a court would approach stare decisis. So we're not quite a court. I would say we have a set of institutional priors, but within those, OLC does strive to provide the best legal advice. Versus the civil division's job is to defend the United States in litigation and sometimes bring affirmative cases. But their standard is, okay, I'm in a court, I am serving my client in a court. Can I make this argument without violating Rule 11, which is a rule banning essentially frivolous arguments? That's not kind of the role that OLC plays.
Okay. And yet, so I accept all of that at face value. And yet, the body of OLC work, particularly on executive authority, is much more forward leaning than, say, most academics, the body of academic scholarship with respect to what the president can do. Some of this I'm quite sympathetic to. For example, while I don't believe in blowing up the legality of blowing up boats in the Caribbean, I do believe in the legality of, say, a drone strike in Yemen that killed Anwar al-Awlaki, which was the subject of a very controversial OLC opinion. But it is fair to say, I think, that OLC opinions, particularly in the separation of powers context, are the sort of gold standard of pro-executivist thinking. Um, and so my question is, how do we reconcile the executivist component of it, i.e., this is not a body of work you look to say, you know, Congress has a whole lot of authority to restrict the president in the following areas, with your job is to give the best legal advice you can.
So there certainly is a little bit of a tension there. Again, I hold fairly strong pro-executive views of separation of powers. So I think OLC has got it right in a lot of ways that people think are controversial. But I guess it's what I said before is the best way to think about it, which is that OLC is giving the best view of the law within a certain with a certain set of priors, and that OLC is situated within the executive branch, and kind of has executive branch interests in mind. We're not OLC is not counsel to Congress. So yes, I guess I would say yes, there's a little bit of a tension, but it is the best view of the law within the set of priors in which we're situated within the executive branch.
Yeah, isn't the right answer to this that this is the job is to get the answer right, but the job is also you do have a client.
Right.
And yep. The client is the executive branch.
That's correct.
And it seems to me OLC's position will always be to give the executive branch the maximum latitude a reasonable view of the law could give it, because you're not a court. Your job isn't to answer in the abstract what the best possible reading of the law is. Your job is to give the best possible reading of the law that maximally enables your client to do the things that it wants to do.
I think that's sort of right. I think you might have said it a little bit more strongly than I would. I wouldn't say that OLC's role is to give the president maximum latitude. But I think this is kind of an unanswerable question, and I will say this is something that, in my experience, OLC attorneys think about a lot, is how do I balance the prerogative of my client with our goal to provide the best legal advice possible. And there's an OLC, I believe it's still online. There's an OLC best practices memo that's available online, which talks a little bit about our role and what we're supposed to do for our clients in terms of providing the best legal answer. And we do, and that is something that OLC attorneys actually think about and kind of and try to follow.
Right. So Matt C. perceptively says this does not sound fundamentally different from a lot of other lawyering.
It's not. No, it's like regular lawyering, and our client is the executive branch.
All right. So let's talk about OLC's status within the executive branch. You said before that an OLC opinion is binding on the executive branch. People misunderstand this a lot, and let's unpack it. What does it mean that it is binding on the executive branch, and why is it binding? It's just legal advice.
So to say that it's binding means that the executive branch has to follow the legal advice that is in that opinion. So the agencies that we deliver the advice to, I would say typically other agencies, if they are faced with the same question, would have to follow it, or they could come back and ask OLC, like, hey, does this apply to us? Or, can we have some clarification? But it means that that is essentially the legal position, more or less, of the executive branch. In terms of why is it binding, I don't have all the specific regs in front of me, and I apologize if I'm getting this wrong, but I believe that one reason it is binding is that the Constitution empowers the president to ask for opinions from the president's heads of departments, including, in this instance, the Attorney General.
The opinion clause, as it is known.
Yes. And there is a Department of Justice regulation delegating the power to issue legal opinions from the Attorney General to OLC. So essentially, OLC is exercising the Attorney General's delegated power under the Opinions Clause. And I guess the Opinions Clause doesn't technically say, like, well, this is binding on everybody, but kind of as a matter of comedy, it's treated that way. Like, okay, we understand this OLC opinion to be the position of the Justice Department, and so the executive branch is going to follow it.
Yeah, so I also think there is a federal statute, and I don't have it in front of me, that essentially delegates the president's law enforcement of responsibilities to the Attorney General. And so to the extent that understanding and issuing opinions as to what the law means is a component of the law enforcement authority of the Attorney General, that is also sort of by reg delegated to OLC. It follows from both what you just said and what I just made up and said, which I think is true, but I'm not going to swear by.
I think what I said is true, but I'm not, 1000%.
That there are two people who can overturn an OLC opinion. One is the Attorney General, whose delegated authority is being exercised, and the other is the president, who, of course, can do reverse anything the Attorney General does or says because he can fire the Attorney General. The number of times that an OLC opinion has been overturned by a president or Attorney General is not zero, but it's not large, right?
It's vanishingly small. I think there was some instance in the Obama administration regarding
DC statehood, I believe. Yeah, okay. So with all of that, Kate asks a very important question in the chat, which is, are there classified OLC opinions and why?
Yes, absolutely, there are classified opinions. Classified opinions exist because the OLC may receive a question, often, but not always, from the White House Counsel's Office, Department of Defense, an agency with classification authority, about an issue that is itself classified. And so in opining on that issue, reading those facts, because essentially the question is classified and involves classified material, the opinion would also be classified.
And one frequent institutional criticism of OLC, which is not in some ways is a criticism of OLC, and in some ways is a criticism of the overclassification by the agencies of the underlying material, is that OLC opinions stay classified too long, and therefore we have these substantial bodies of internal executive branch law that are essentially secret. There's also substantial delays often in publishing non-classified OLC opinions. To what extent do you think this criticism has merit, and that there is a sort of an unnecessary degree of obscurity in OLC's positions on a number of issues?
I have a very cranky view on this, which is that I don't understand why OLC opinions need to be public in general. It's legal advice provided to a client. You know, the GC of companies don't typically publish their legal advice. And our job is not to create, it's not to like publish judicial opinions. OLC's job is to answer questions from the client. And I still don't understand why all of that is not considered attorney-client privileged and or deliberative process work product privileged. And again, I'm speaking totally for myself in this extremely cranky view that I hold.
I just want to say I could not disagree with this view more strongly. Let's bracket it and yell at each other over scotch about it.
Okay.
All right. All of this brings us to the question that people wanted to hear from you about in the first place. And I want to stress that as far as either Janine or I knows, all of this took place after Janine left the Office of Legal Counsel. And so she is talking here on the basis of no firsthand knowledge of anything. She's read the newspapers just as the rest of us has, and she's aware of the president's statements, and doesn't know anything except institutional knowledge about the way OLC works that the rest of us don't know.
Yep.
So she is free to speculate recklessly as the rest of us are. All right. Imagine I'm the president.
That's
And yeah, well, it's the closest you're going to get to the reality. If when I become president, you can be White House counsel.
awesome.
And imagine I decide I want to blow up some boats in the Caribbean Sea. And imagine that there is no relevant authorization to use military force. And so maybe when I chat with Pete Hegseth about this, the Defense Department General Counsel raises the question, would that be murder? Let's just imagine the policymakers get together and say, we want to blow up some boats. And how does this describe a process by which we go from that conversation, where Pete Hegseth is like, rearing to go because blowing up boats is like a way to show masculinity, and Trump just loves anything that involves, killing Latin Americans. And so you have, and by the way, blowing up boats, lethality, right? And that's the new buzzword at the Pentagon. So tell me a story, it's entirely made up for those who want to, pretend that we're back channeling some secret. Neither of us knows shit.
Yep.
Tell me a story about how we go from Pete Hegseth doing pull-ups and going, yes, sir, we're going to blow up some motherfucking boats. We're going to take it to Trinidad, to an OLC opinion, which has been reported to exist, saying the president has, kind of inherent authority to blow up boats.
Okay, so yes, underscoring that Ben is totally right. I am speculating as a private citizen. I know absolutely nothing about how this actually happened. And I will also say that everyone has been deriding the existence of this purported OLC opinion. We haven't seen the opinion. It is I am not ruling out the possibility that it says something very convincing as to why the president has this authority to blow up drug boats in the Caribbean. But
we're going to get to the range of possibilities about what that could be in a minute.
Okay.
But let's start with the procedural components. How does the opinion come to be?
So again, this is a little bit above my pay grade, but I can speculate. The opinion would come to be because presumably the Defense Department, intelligence community, White House are having discussions about this idea about something they want to do, and they're not sure whether it is lawful, and they would like advice on whether it is lawful, among other things, to be sure that they're not violating federal law on murder, like you just said. So I suspect, although again don't know, that this would come about because genuinely, like, executive branch officials want to make sure that they're not violating the law and not doing something that could have, serious repercussions for them. And
sorry, go ahead.
And so then typically OLC interfaces with like I said, the general counsel of an agency or the White House counsel's office. So the general counsel of DOD or the White House counsel would contact OLC and say, like, hey, we have this question. This is what we want to do. This is what we think our legal authority is. And that's important, actually. OLC always or typically asks for a views memo of the agency that is asking the question, because OLC is not experts in particular issues. OLC is generalists and deals with whatever issues get thrown at us. So sometimes, or a lot of times, an agency will know their own authorities better. So when they ask a question, OLC wants the agency to say, like, this is what we think our legal authority is. And that provides a good starting place for OLC to answer that question. So yeah, typically a question like this would come in from general counsel, White House counsel's office, and they would say, can we do this? And OLC would, based on the authorities that they've provided, and also, OLC, like our own research and prior opinions about the president's Article 2 authority, would issue an opinion saying, yes, you can, or no, you can't.
All right, so let's take an example of this that we actually know the history of, which is the CIA's coercive interrogation program, aka torture. And I know both of the referring lawyers on this matter. One was John Rizzo, who was the acting general counsel of CIA at the time, who is now, alas, no longer among the living. And the other was a longtime, he's a good friend of mine, a longtime attorney in the CIA general counsel's office, who was then the head of the counsel for the Counterterrorism Center, which got assigned this function. His name is Jonathan Fredman. And Rizzo was always very clear about what motivated him in this, which was protecting his people. And, he I mean, I don't know if I think he said it publicly, but he always made very clear, I am not letting CIA personnel do anything that justice doesn't specifically sign off on. And was a little bit surprised at how willing to sign off on specific techniques John Yoo was at the time. Um, but Rizzo, I don't think he was motivated um, by abstract curiosity about the limits of the law. He was motivated by the fact that President Bush had said, basically, do everything that's lawful to, take, put your toes on the line of the law and lean, um, to prevent anything like this from ever happening again. And this, the relevant statute had no history of interpretation. And so they had this list of procedures that these psychologists had come up with, and they had no guidance as to what they could and couldn't do. And so there was an element of, I don't think John would object to saying this. There was a real element of CYA where we're not going to do anything justice says we can't do. And I believe there was one procedure that justice said they couldn't, maybe two. Um, and we're just going to put everything out in front of the Justice Department, and it's going to we'll do what they say is legal. Um, how much of it, in your judgment, in a situation like this, is personnel in DoD and the intelligence community saying, I'm not doing this without a clear statement by the Justice Department that this is lawful, and how much of it is genuine, like, not abstract
Right.
curiosity, but like, we're trying to understand the contours of the law here in a fashion that is more like legal advice and less like legal cover? Or are they even different?
I don't know how different they are. I wish we had Marty here because I think he would know more of like what motivates an agency to ask a question to OLC.
And
But
this is Marty Lederman, who is understood to have been either one of the authors of or the principal author of the Alalauki opinion and other similar
I
documents.
actually think I knew that. Wow.
Well, that is my understanding,
Sure.
and I will say that whether that is not because Marty has ever said to me, "I wrote it," but that is, I think he and Dave Barron, who is now a judge on the First Circuit, were the principal actors behind it.
Um, right. So sorry. Right. Difference between cover your ass and legal advice. I don't actually know that there's all that much daylight between it. If an agency is concerned that something that has been proposed to them or that they've proposed is legally iffy, I feel like both of those factors would come into play. Of like, well, we have an obligation to act within the law. I mean, I would hope what comes into play. And in my limited experience, I do think typically most executive branch officials take their responsibility to act lawfully seriously. Um, and the flip side of that is like, well, what legal consequences could there be for us if this turns out to not be lawful? So I'm not sure that there's a ton of daylight there.
Right. CYA and legal advice are kind of the same
Yeah.
because the nature of legal advice that you can do something is that it sees YA for that thing, and the nature of legal advice that you can't do something is your ass isn't covered if you do. All right, so let's talk about how a responsible OLC opinion could have gotten to this result. And again, the opinion isn't public. I have no inside knowledge of this. Janine has no inside knowledge of it. So we are speculating based on what we know about public OLC opinions across a long period of time. Is that fair?
Yes, that's correct.
All right. So it seems to me that, first of all, most, but not all, of the war on terror opinions are going to be hard to apply here because of the absence of the AUMF,
Yes.
right? So in most situations, OLC tries to rely on statutory authority rather than constitutional authority. The AUMF, notwithstanding the protestations of lefty law professors, is actually super broad and provides a lot of authority to use military force. We can go into that. It does not provide any authority to target Venezuelan gangs. Is that fair?
Yes, I would say this is not an AUMF issue.
Right. So, in the absence of congressional authority, well, let's pause there. Is there any other plausible congressional authority that could get you to blowing up a boat?
Not that I know of, but maybe there's something that I don't know of. There's no active AUMF that I am aware of that would authorize military force against drug boats in the Caribbean.
All right. So then you fall back on, is there some inherent authority in Article 2 that authorizes the president in his commander-in-chief role to take military action in the absence of congressional and authorization? And generally speaking, we only have 4 minutes left. So you've got your self-defense rationale. Canada invades the United States. The president doesn't need to wait,
Yep.
right? Then there's imminent preemptive self-defense. We believe Canada's about to invade the United States, so you can, nuke Toronto without waiting for him to.
That's the Caroline case, I believe.
Right. And then you have some other body of law that OLC has articulated over time that involves some pressing national interest some pressing national interest that is not self-defense, but is, say, protecting Albanians in Kosovo from Serbs, or collective self-defense and attack on our allies. So put this together, and what is the best argument you can make off the top of your head that there's some constellation of these OLC positions that collectively get you to, there's a boat that we think is bringing drugs, so let's just blow it up.
Yeah.
And to what extent does the fact that we have a Coast Guard that could interdict that boat, and so we have a non-kinetic military alternative, play into the discussion? You have 3 minutes.
Oh boy! Okay. So I am not as convinced as others that this opinion must be completely lawless based on prior OLC opinions. The test that OLC has developed for the use of force has become extremely broad over the years. And I believe that the most recent iteration, as issued as available in public opinions, for whether the president can use military force under his Article 2 powers as commander-in-chief, is whether military force is in the national interest and it does not rise to the constitutional level of war. And that's really broad. There are a set of interests that OLC has articulated qualify as like within the national interest. I don't remember them all off the top of my head, but self-defense, obviously, protection of American citizens and property, even abroad, is one of them. Preserving regional stability, and I believe defense of allies, although I'm not entirely sure. But basically, there have been a bunch of things that OLC has said, like, yes, this is an appropriate national interest. I don't know which of them would fit the Venezuelan drug boat situation, but if I'm trying really hard, so you could articulate a new national interest. You could say, well, these people are bringing in drugs that have had this epidemic on United States citizens, causing all of these fentanyl deaths. It's in the national interest to eliminate them. Or you could try to sort of make it into kind of a protection of American citizens argument, like based on what I just said, that like these drugs are harming Americans. It's an epidemic. We can't stop it in other ways. And so to protect American citizens, we are gonna blow up this boat. That would definitely be an expansion of the protecting American citizens and property interest, but I'm not saying that it's completely absurd. And then in terms of the fact that we have a Coast Guard, that's a really interesting question. And I don't actually know how that interacts with the Article 2 test, because I mean, typically in these other cases, can we bomb Libya, or can we drone strike somebody in Pakistan or Syria? There just like isn't a criminal option, an enforcement of criminal law option. So off the top of my head, I can't recall an OLC opinion that sort of grapples seriously with, well, there is a criminal law option here.
I can.
The Alawaki one?
Yeah, the Alalauki one proposed, but now this is for a U.S. citizen.
I was gonna say that is different because it's a due process issue.
Proposes a 3-part test: senior operational member of Al-Qaeda whose capture is not feasible and whose targeting would be consistent with the laws of war. Here, the capture is totally feasible.
I would say that's actually just not applicable, because in my recollection, that is not a test for Article 2 use of force. That is a test for whether that use would be comport with the due process clause. And Alawaki had due process rights because he was an American citizen. As far as we know, the Venezuelan drug boat people are not American citizens.
So I accept that prior OLC art is sufficiently broad that you can, jam some public interest, national interest rationale through this. But that seems to me to be evidence that OLC's prior art is too broad.
I actually agree.
In the sense that, like, if what we really mean by national interest is some interest that's perfectly accomplishable by other means, but you just choose to use murder as your way to do it, I'm not sure that's a good legal test. All right, we are already over, but Holly Berkeley Fletcher would be upset at me when she emerges from her MRI machine today if I did not pose the following question to you. This is now switching capacities as one of our Taylor Swift correspondents. Holly wants your overall impressions of the new album, your favorite songs, and she wants to know what you make of the criticism that it's all anti-feminist or that it's pure fluff at a time of national turmoil.
My gosh, how could you possibly give me this question when we're over time? I have so much to say about it.
The gentle lady, as they say in Congress, shall take such time as she may require.
Okay, so I like the album. I think that it is good. I think that a lot of songs are so catchy. It's not the Tortured Poets Department. It's not one of my favorites, but I think that it is good. And it took me a couple listens, and Taylor Swift honestly always takes me a couple listens to sort of get my head around what she's doing this album. But I really like it. I think in general, the songs are somewhere between pretty good and great. Favorite song, Father Figure. Absolutely. It's just like injected into my brain. I love the storytelling there. I do think this album is a little light on the kind of storytelling element that she has in her songs, but that's not new for her. Like, people criticized 1989 for that. 1989 slaps, and it's the best album that she ever wrote. And B, there are some great storytelling moments on this album, particularly Father Figure and Ruin the Friendship.
Anti-feminist?
Oh my God, touch fucking grass, okay? That's my official statement on it. It's like, oh no, like, how could she be really...
And by the way, the touch fucking grass, you can attribute that to the Office of Legal Counsel of the United States Department of Justice.
Please don't do that. No, you can't. Like, how dare she be happy when bad things are happening? Like, what is wrong with you people? Not everybody has to be miserable all the time. She's not issuing a statement on the world. She's making songs that are mostly about her life. So no, it's not anti-feminist for, by the way, the most successful woman in the world who's is essentially a self-made billionaire, through her art, to say, like, I would actually really like to have a husband and kids, and I'm excited for that. She's not saying, yes, I now that I have this, I'm going to become a trad wife. She's actually specifically said in interviews that it's really offensive for people to say that she's going to stop making music now that she is getting married to Travis Kelce. So yeah, people can have lives and be happy even when bad things are going on. And as a feminist, it is incredibly not just wrong, but stupid for somebody to say that it's anti-feminist for a woman to want to get married and have kids. Because, by the way, lots of people want that. And it's not a success. So that's not a successful way to advertise or grow the feminist movement.
Total fluff in times of national turmoil?
Why are you asking a pop star to talk about national turmoil?
We are going to leave it there. Janine Balekdjian, loud person, former OLC attorney, future, as of Monday, something else, correspondent for Dogshirt TV on all matters Taylor Swift and others. And as you can see, super substantive and eccentric mind on many subjects close to all of our hearts. Thank you for joining us today.
Ben.